Welcome to our Illinois Chamber of Commerce webinar today. My name is Kirsten Constant and I am the Business Services Coordinator here at the Illinois Chamber. Today's webinar is titled Anti-Sexual Harassment Training. Our presenter today is Jeff Risch with Smith Omninson, and we are going to go ahead and get started.
I am a management side labor attorney, and I am partnering with, and my law firm is partnering with the Illinois Chamber of Commerce to present this training for you today. In registering and participating, of course, the material today is not to be construed as legal advice. I'm not your lawyer. I'm not providing you with legal advice. This is educational material. This is training material designed to comply with the requirements and the mandates specific to the Illinois Human Rights Act. The training is presented today in a form and a style that's not designed or intended or it's not to be construed as unique to your operations or any particular employer or employee. The training presented should not be utilized, really shall not be utilized or relied on by anyone working in the restaurant or bar industry. The restaurant and bars that employ you have specific and additional requirements under the Illinois Human Rights Act. And of course, by registering and participating in the training, your organization agree to waive any and all rights or claims against and hold harmless any and all loss or legal claim, the Illinois Chamber of Commerce, yours truly, the presenter, and or the law firm of Smith Omninson. All participants in their organizations are solely responsible for all legal obligations, responsibilities, liabilities they may have under the law, including but not limited to the training, certification of that training, record-keeping requirements, and other obligations under the Illinois Human Rights Act or any other law. So what every employer must strive to do, as a reminder, as an introduction, of course, all employers need to adopt and actively implement written policies and practices to help ensure that the workplace is safe for employees to report concerns about sexual harassment. And for that matter, any other form of unlawful harassment or discrimination. And what's key is without fear of retaliation or retribution. No employee should be afraid or fearful of reporting things that they find to be hostile, harassing, that they perceive to be wrong in the workplace, whether it's related to allegations or instances of sexual harassment or any other form of unlawful treatment in the workplace. Employers should be adopting policies and practices to invite and do the exact opposite, to actually invite and create a culture of inviting employees to report things that they find to be out of sorts, that they find to be, maybe the word off, or something's just not right going on in the workplace. We should encourage employees to report those instances. We need to ensure that all employment decisions that may impact terms and conditions of employment are not based on any unlawful basis, such as gender, race, sexual orientation, and the other characteristics that are protected by local, state, or federal law. To be clear, we will discuss and cover an explanation of sexual harassment under the law. So under the law, under the legal framework, what is sexual harassment? We're going to provide examples of conduct that constitutes unlawful sexual harassment. We're also going to provide a summary, and we're going to review a summary of federal and state statutory authority provisions, the law, concerning sexual harassment, and including what remedies are available to victims of sexual harassment. And of course, a summary of the responsibilities that employers have to prevent, investigate, and correct instances of sexual harassment in the workplace. These four topics will be examined closely, and these four topics is exactly what the state of Illinois, under the Illinois Human Rights Act, requires all employers to review and cover with the Illinois mandatory training components, now part of the Illinois Human Rights Act. So let's talk about, sexual harassment. The state of Illinois, and this is not unlike federal law. The state of Illinois has always has for years made it a civil rights violation, made it illegal for an employer, an employee, an agent of an employer, an employment agency, or a labor organization to engage in sexual harassment. It's illegal. Sexual harassment is illegal under the Illinois Human Rights Act. The Illinois General Assembly, the state legislature, the politicians in Springfield, they find that tolerance of sexual harassment has a detrimental influence in workplaces by creating a hostile work environment for employees, reducing productivity and increasing legal liability. And of course, the state of Illinois encourages employers to actively implement these policies, these written policies, to try and ensure their workplace is free from and safe for employees, free from sexual harassment and other forms of unlawful harassment and discrimination, but again, safe for an employee to report concerns about harassment in the workplace without fear of losing my job or not getting the promotion. So other objectives and points of discussion. Since we have the hour to discuss and review sexual harassment and go through all the ins and outs of sexual harassment in the workplace, it's probably a good idea to address other things in the workplace, including any form of unlawful harassment and discrimination. Let's talk about diversity and how diversity plays specifically in the interaction with others during the workday, because we all come to the work site or to the office or to the plant, the facility. We're using our email and interacting with customers and vendors and suppliers and coworkers and subordinates and managers. We all come to work with extremely unique backgrounds, views, and personalities. So let's talk about that a little bit, because I think it's going to help us in our behavior and our conduct in the workplace. Let's discuss the legal definitions of all forms of unlawful harassment, discrimination, and try to prevent it. Well, let's not just discuss sexual harassment. Let's go talk about other forms of harassment, discrimination in the workplace from a legal lens. Let's talk about, put the law to the side for a moment. Let's identify risky workplace behavior and conduct and appreciate why we need to avoid it. I mean, there's a lot of conduct and behavior in the workplace, and I'm using that phrase workplace very broadly. We're going to talk more about that. It's not just the physical workplace. It transcends the physical brick and mortar of an office or a building. But let's talk about risky workplace behavior and conduct that is just foolish, unprofessional, annoying, and you don't need this annoying, unprofessional, foolish behavior and conduct in the workplace, because it's not going to lead to anything that's positive or productive, and could very well spill into an environment that may be considered unlawful, depending on the subject and the facts and the circumstances. And finally, let's talk a little bit about your responsibility concerning avoiding, preventing, reporting, resolving, and remediating harassing or discriminatory conduct in the workplace. Hey, we all have that responsibility as human beings, as employees. And so we'll talk a little bit about our own self-responsibility in this whole thing. So in Illinois, just so you know where we are today and where we'll be tomorrow, in Illinois, employers are required to provide sexual harassment prevention training for all employees. Every employer in the state of Illinois is required to provide employees with sexual harassment prevention training on an annual basis. So yes, what you do in 2020, when you hear this recording, you may be listening and hearing or seeing the same material in 2021. You have until the end of the year, December 31st, 2020 will take care of you for the year 2020. And then 2021, 2022, and so on and so forth. All employees, regardless of their status, I don't care if you're a short-term employee, a seasonal employee, a part-time employee, I don't even care if you're an intern, an unpaid intern. I don't care. You need to be trained. You need to be trained. Employees it's a broad term and definition under the Human Rights Act. And even independent contractors, bona fide, true, blue, independent contractors working on site alongside an employer's workers should also, at a minimum, acknowledge and attest that he or she has received sexual harassment prevention training in compliance with Illinois mandates. So we're working in an increasingly diverse world, are we not? Diversity in the workplace. We hear that phrase a lot, and I'm not an academic. I'm not a lawyer's lawyer. I am just somebody who looks at, I hear this word diversity, and I'm not I don't focus on diversity in the workplace. But here's what I do understand, and what I think helps when we talk about the rules of engagement and workplace conduct and behavior. I think if we understand and of course respect other people's differences, but understand and appreciate that not everyone sees things the same way you do. In fact, I would say that not everybody sees the same things in the same way that they did yesterday. Maybe that's probably a better way of looking at it. I mean, you, me, your coworker, your boss, we come to the workplace and we have, especially nowadays, we have a lot of baggage. We've got a lot of things going on in our personal lives that impact what we say, what we do, and maybe more importantly, how we perceive our work environment, how we perceive other people speaking to us and talking to us and interacting with us. And so we come to the workplace and we have different personalities, we have different ambitions, we have different political views, we have different sense of humor, sensitivity, creativity, intellectual abilities. We have all these different, things going on in our lives, health issues, financial circumstances, these stress factors. And we bring this to the workplace every day, and it changes. So how we perceive others, what we thought, maybe I phrase it like this, what we thought was funny, comical, or even maybe not so funny, but tolerable last week may be fundamentally different than how we're going to see that same thing tomorrow or next week or next month. I ask this question a lot. Are you the same person that you were 20 years ago? Are you the same person you were 10 years ago? People change. You change. We evolve. And so the point here is that when we go into the workplace, we have to understand that just basic human interaction changes day by day. And the run up here is, of course, we have to We have to respect people. We have to respect their differences. They're not like us. Not everyone is like us. In fact, we're all very different in many, many different ways. It's not just skin color. It's not just gender or gender identity or sexual orientation. We all come to the workplace. We may look a certain way on the outside. We may demonstrate certain tendencies, but we change, and we're way more complex today than we were yesterday. And so listening and observing and figuring out how people want to be treated in the workplace and maybe modify your interaction appropriately, you got to be able to read people in the right context and situations. Of course, the bottom line, I think, here is you don't know when you cross the line until you cross the line. What you said or do today may be hysterical to your coworker. Tomorrow, that coworker, or later today, that coworker, their view may change. Crossing that line, that invisible line, comes very easy and very quickly in today's times. So with that in mind, let's talk about the definition of unlawful discrimination. And we're talking about under the law and specifically the Illinois Human Rights Act. Unlawful discrimination, it means something bad happens in the workplace. Something bad, there's an adverse action has happened. There's been an adverse effect on an individual because of that individual's real or perceived, including perceived, race, color, religion, national origin, ancestry, age, sex, gender identity, marital status, order of protection status, arrest record, citizenship status, disability, military status, sexual orientation, pregnancy, unfavorable discharge from military service. And there's other characteristics that can be protected by local, state, and federal developing employment law. So there are specific categories, right? There's specific categories. I mean, I guess let's just back up. I mean, I suppose that if there was an adverse action, if I'm terminating Phil, and Phil says, "Why are you terminating me, Jeff?" And I said, "Phil, I'm terminating you because you are a Green Bay Packers fan. And I'm not going to have you working for me anymore because you're a Green Bay Packers fan." It's a silly reason to terminate Phil. It has Phil maybe guessing and speculating. Maybe that's not the real reason, because I know that Pam in accounting, I know she's a Green Bay Packers fan. But put that to the side. Me terminating Phil on its face because he's a Green Bay Packers fan is not necessarily discriminatory. I mean, it's kind of silly and foolish, but it's not discriminatory. Now, if the real reason is because of Phil's age, if the real reason is because of Phil's gender, if the real reason is because of Phil's sexual orientation, and I'm just using the Green Bay Packer thing as an excuse, well, then that would be a problem. But unlawful discrimination is very specific to categories of protection that the law recognizes. And up to this point, has said, let's protect these categories. So harassment defined under Illinois law. Under Illinois law, harassment, which is a form of discrimination, means any unwelcome conduct on the basis of an individual's, again, actual or perceived race, color, religion, national origins, ancestry, age, sex, marital status, order of protection status, disability, military status, sexual orientation, pregnancy, unfavorable discharge from the military service, or citizenship status. That has, and this is important, that's why it's in red, it's important, that has the purpose or effect So it's harassment in the workplace. It's unwelcomed, it's unwanted. We'll talk a little bit more about that. It's unwelcome conduct that has the purpose or effect of substantially interfering with the individual's work performance, ability to do the job, or creates an intimidating, hostile, or offensive work environment. And again, that phrase work environment, it goes beyond brick and mortar. It's not just the physical location where an employee is assigned to perform their duties. Now, that definition of harassment, that's not my definition. That's the definition recognized by the Illinois Human Rights Act, by the state of Illinois. And that's not just unique to Illinois. I mean, on a federal level, on a more broad approach, while the federal government, for example, Title VII doesn't recognize directly, it doesn't recognize, let's say, order of protection status. It recognizes race and age and gender and disability, and it prevents, disability would be under the ADA. But my point is that this definition, the Illinois legal definition of harassment, is not that much different than what the federal government would categorize as workplace harassment. It's harassment, and it's related to a protected basis that substantially interferes with someone's ability to perform their job or otherwise creates an intimidating, hostile, or offensive work environment. Now, sexual harassment, we talk about harassment, we've got to talk about sexual harassment, right? Sexual harassment is a form of harassment. Remember, I said harassment is a form of discrimination? Well, sexual harassment is a very specific form of harassment, unlawful harassment. And under Illinois law, sexual harassment means any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature. The sex has to be part of what's going on. It has to be part of the vocabulary, the behavior, that conduct, the behavior that is of a sexual nature. Well, when submission to my sexual advance is made either explicitly or implicitly a term or condition of an individual's employment, well, yeah, I mean that's of a sexual nature. You gotta have sex with me, and if you don't, it's your job. That or I'm at least implying that it's your job if you don't have sex with me, or submission to or rejection of the sexual advance or the sexual conduct by an individual is used as a basis of employment decisions affecting such individual. So if you're going to have sex with me, or if you don't have sex with me, it could create, it's going to create a problem for you, because it's going to impact my decision of whether or not I'm going to promote you or whether or not I'm going to demote you. Of course, conduct that has the purpose or effect, the sexual conduct, sexual advances, a conduct of a sexual nature that affects or has the purpose of substantially interfering with an individual's work performance or otherwise creating that intimidating, hostile, or offensive work environment, that is also a form of sexual harassment. So that's that's a lot of legalese. That's the legal definition of sexual harassment, not unique to Illinois. A lot of states have similar definitions. The federal law is very similar to the Illinois definition of sexual harassment. And again, the work environment is not limited to physical location that the employee is assigned to. So I'm going to break down sexual harassment so it's a little bit easier to understand here in a moment. But before I do, when we talk about that hostile work environment, let's back up for a minute. You remember, there's that form of sexual harassment where I'm going to use sex as a weapon, to quote Pat Benatar. I'm going to use sex as a weapon. Well, it's easier to see, when you see that or you hear it, you say to yourself, yeah, you can't use sex as a weapon. Employers, bosses, managers, supervisors, you can't use sex as a weapon in the workplace. That's kind of a no-brainer, right? But a more subtle form of sexual harassment is usually in this form of this hostile work environment sexual harassment. Sexual conduct, sexual behavior, conduct of a sexual nature that interferes with someone's ability to do their job, creating an intimidating, hostile, or offensive work environment. So you go to the question we should all be asking ourselves now is, well, what's the standard used? Who determines a hostile work environment? Who makes the decision or the determination where something is said of a sexual nature and now it's creating a hostile work environment? Now it's interfering with the individual's ability to perform their job. So the standard is really twofold. The victim, in their own mind, needs to be offended as to what's going on. They have to be subjectively offended in their own mind. That is used, not always, but that's often sort of a gimme. It's like a given, right? If a victim is saying, I'm offended, they're offended. It's hard for me to argue what they're feeling inside and what they're articulating. A reasonable person standard, though, is also applied. And so whatever is happening in the workplace, a reasonable person observing it in the same work environment, in similar environment, under similar like circumstances, a reasonable person would be offended of what's going on. So that reasonable person standard is designed to make certain that it's not just the victim who is offended, but a reasonable person would be also offended in like circumstances. So there's a subjective standard and an objective standard. So what is unlawful harassment discrimination simplified? Employment actions that adversely affect an employee because of real or perceived protected characteristic, for example, gender, recognized under applicable local, state, or federal laws. Terminating the employment relationship for Susan because she is a woman is illegal. Terminating Susan because she is legitimately a poor performer is legal. So I'm terminating her because she's a woman, illegal. Terminating her because she's a poor performer, legal. And there's examples of adverse employment action. For examples, discharge, termination is of course the most common, but a failure to promote, demotion, negative change in benefits, adverse compensation decisions, significant change in job duties that are negative. Harassment is another form of adverse employment action where on-the-job harassment that substantially interferes with one's ability to perform their job or otherwise creating a hostile work environment, that's adverse action. Now, adverse action can take place if, like, for example, termination or a failure to promote or demotion certainly can take place. It takes place all the time. There's things that happen in the workplace where the employee doesn't like. And if it's supported, if that business decision, which you might not agree with, an employee might not agree with it, but ultimately, if it's supported by legitimate business reasons, that's the phrase, legitimate business reason, legitimate, not based on gender, not based on race, not based on religion, not based on sexual orientation, but based on legitimate reasons that the employer can articulate and perhaps even, if push comes to shove, show and demonstrate that it is legitimate, those adverse actions are generally lawful. Now, let's go back to harassment, because we talked about sexual harassment and using sex as a weapon and then the hostile work environment. The sex as a weapon type of sexual harassment is sometimes it's referred to as quid pro quo. So this is unique. When we talk about workplace harassment, whether it's age or sex, quid pro quo is a type of harassment that is unique to sexual harassment. This is the type of harassment of a sexual nature where submission to or rejection of sexual advances or sexual conduct is used as a basis for actual employment decisions affecting the individual based on the individual's submission to or rejection of the sexual advance or the sexual conduct. The clearest example I can provide is the boss demanding sex from his or her subordinate. You do this for me, and I'll make sure you get the promotion. Wink, wink. Or maybe it's not wink, wink. Maybe it's not subtle at all. This type of harassment is unique to sexual harassment. It requires the boss, a manager, a supervisor, somebody with authority over someone else to be able to successfully make good on using sex as a weapon in the workplace. How many times can the boss demand sex from his subordinate until it's illegal? Well, the answer is, if it happens at all, it would be illegal on its face. If I'm using sex and threatening adverse employment decisions, or subtly implying that I would use sex as a weapon with a subordinate, that is illegal. I don't get two bites of that apple. You can't do it. You can't go there in the workplace. Now, again, quid pro quo is when the boss, and I use that term broadly, the boss demanding sex and using sex as a weapon and weaponizing sex in the workplace. If a subordinate is trying to use sex as a weapon against his or her boss, that's not quid pro quo. What it could be is hostile work environment. In hostile work environment is in my experience as a practicing attorney, this is the form of harassment that I see more often. And there could be, I'm not here to debate with the reasons for that, but unlike quid pro quo, this is more of the subtle behavior and conduct, or not so subtle behavior and conduct that happens in the workplace that ultimately gets a lot of managers and supervisors and employees, because you don't have to be a manager or supervisor to engage in this hostile work environment type and form of sexual harassment. This is the type of harassment, again, that unreasonable from a subjective viewpoint and an objective reasonable person viewpoint that interferes with an individual's ability to perform their job or creating a hostile, intimidating, or an offensive work environment. Even though the harassment may not result in job loss, or it may not necessarily result in economic negative job consequences, it's still, if it occurs, it occurs, and it's unlawful, and employers need to make sure that they're preventing that from happening. Hostile work environment, employers can engage, supervisors, coworkers, customers, clients, vendors, suppliers. Anyone can create a hostile work environment. Hostile work environment harassment can also form the basis on any other protected characteristics. So, like quid pro quo sexual harassment is unique to sexual harassment. Hostile work environment harassment is a type that can transcend other forms of discrimination, real or perceived race, religion, gender, age, sexual orientation, and that list goes on under Illinois law, right? So unlike quid pro quo, which is unique to sexual harassment, hostile work environment transcends. It's not just, it doesn't have to be solely based on sexual conduct. It can be based on racial, religious, age, gender, sexual orientation. There's other protected characteristics that can be harassed in the workplace, creating a hostile work environment. Now, specifically, examples of sexual harassment. Hostile environment sexual harassment may include, doesn't have to include, these are just examples. This isn't set in stone, but these are some common examples. Repeated requests for sexual favors or pressure to go out on a date, demeaning sexual inquiries and vulgarities, offensive language of a sexual nature, other verbal or physical conduct of sexually degrading nature, sexually offensive, explicit, or sexist signs, cartoons, calendars, literature, or photographs displayed in plain view, sexually offensive and vulgar emails and texts. And you can insert other forms of harassment here. Like, what about demeaning racial inquiries and vulgarities? What about offensive language of a religious nature? What about verbal or physical conduct of a degrading nature related to age? Sexual harassment may also include deliberate touching, leaning over or cornering another person, sexual lurks or gestures, like elevator eyes, whistling at someone, sexual teasing, jokes, remarks, or questions, referring to someone as girl, hunk, doll, babe, honey, tootsie, actual or attempted sexual assault or battery, obviously, turning work discussions into sexual topics, talking about sexual fantasies, preferences, histories, sexual comments, sexual innuendos. You don't have to be that specific. You can be a little bit more, subtle. And if it's sexual innuendos, it's not going to fly. Sexual stories, sexual comments about a person's clothing, body, or looks, kissing sounds, howling, smacking lips, telling lies or spreading rumors about a person's sex life, massaging necks, shoulders, touching another employee, the clothing, hair, or body parts. I mean, it kind of comes in different forms. Conduct that is not unlawful, if it's welcomed and wanted, it's not unlawful. But remember when I said at the beginning, the invisible line, crossing the line is so easy, and you can quickly cross that line. What is welcomed and wanted today may be unwelcomed and unwanted tomorrow. You need to keep that in mind, folks. The workplace is not a forum to roll out your new material. It's not a place to find your soulmate. Now, we can exchange common pleasantries. We can have acts of courtesy, appropriate compliments. That's all great. Appropriate lunch or dinner date. That's fine. That's great. But we are in a diverse world. We are in more and more diverse workplaces. We don't know what's going to be offensive to our coworker, or to our subordinate, or to our boss tomorrow or next week or next month. You can cross that invisible line at any time. Generally, we talk about unwelcome. It means the victim didn't solicit it, didn't invite it. The victim didn't come up to you and say, hey, tell me that dirty joke again. Welcome behavior can quickly become unwelcome. What starts off as welcome behavior, consensual joking, can cross a line and become unwelcome quickly. And ladies and gentlemen, just as a lawyer that practices in the trenches, that's usually what I see. This is usually what I find in my experience. What was funny today, or what was tolerable today, just becomes intolerable tomorrow. And there's a crossing of a line somewhere. Remember, consent, that welcome, that want it, can be revoked at any time. And when somebody says, hey, you know what, and now it's becoming intolerable, or now it's becoming, it's at the point where I don't want this anymore, then that victim or that person needs to say, stop it. Stop talking to me like that. Leave me alone. Jump in a lake. Back off. I don't know what the cool kids say these days, but whatever it is, stop. And when stop is said, or anything related to leave me alone is said, then it needs to stop. You can't say, as the perpetrator, you can't say you started it or you were okay with it yesterday, so I'm going to keep it up. You can't do that. So that welcomed and wanted, that invite can be revoked at any time. Who can be harassed? A victim can be a woman or a man. The victim does not have to be of a different race or national origin. All persons can be victims of sexual harassment, regardless of the victim's gender identity or the perpetrator's gender identity. All persons can be victims of harassment, regardless of the victim's sexual orientation or perpetrator's sexual orientation. A gay man can sexually harass another gay man. A gay man can sexually harass a heterosexual woman. There's no rules with if you're in a protected category, that gives you the right to harass or discriminate against somebody in your same protected category classification. The victim can be a non-employee. The victim can be an indirect party. They're not the target of the behavior. They're just overhearing it. They're observing it. They're the bystander. Anyone can be harassed. Who can be the harasser? Surprise, surprise. Anyone can be the harasser. Direct supervisor, manager, any supervisor or manager. A subordinate can harass the supervisor. Co-workers, peers, colleagues, non-employees, vendors, suppliers, customers, the public, who are foreseeable. The person who is sexually harassing Barb, when Barb picked up the sandwiches for the meeting, well, did you know she was going into the sandwich shop to be harassed? No. But if she's harassed by somebody working at the sandwich shop and you say, Barb, she reports it, and then the next week you send her back to the same sandwich shop where she can be harassed again by the same person working at the sandwich shop, that would be a problem. That would be a foreseeable non-employee. So non-employees, an employee's work environment is not limited to the physical location where the employee is assigned. It's wherever they're moving. So they're interacting. Your employees are interacting with the public, customers, suppliers, vendors, right? And remember, your employees, Barb can harass the person at the sandwich shop. It's vice versa. The non-employees can be victims of sexual harassment or perpetrators of sexual harassment. Now let's talk quickly about risky behavior, avenues to avoid. We want to avoid physical, visual, and verbal. And these are sort of the topics, the categories, the physical, the leaning over somebody, the gestures, the massaging, the elevator eyes, hugging, kissing. I try to avoid that stuff. My rule in life is I'm not a hugger by nature, but I don't hug. I don't hug. And I don't massage. and I'm careful with my physical interaction with other people. Visual, it doesn't have to be something that's real. I mean, it could be a cartoon, it could be made up, it could be an image, it could be an email, all those emails and the texts and the social media. And yes, employees can harass each other through social media off-site and off hours. It involves employees, and that's an issue. That's a problem. Verbal, there's stories, there's real or made up stories. It doesn't have to be real. There's jokes, remarks, questions, obscene language, name calling, inappropriate comments. Even though you're trying to flatter somebody, you're offending them by making comments about their body. I got the red highlight here on jokes, remarks, or questions. what's common is some questions. I think sometimes people will make a remark or a question of somebody, whether it's sexual, it involves sex, or it's of a sexual nature, or it involves someone's religion or race, and it may be an innocent question. They may perceive it, the person who's asking the question may be asking it, in their mind innocently, but it's coming across as inappropriate, condescending, insulting. There's a lot of things in the workplace that are risky. There's things that are in the workplace that don't relate to actual business at hand. And when you start getting into areas involving age or race or religion or ethnicity or culture or politics, it can create annoying, silly, uncomfortable situations, uncomfortable topics, and you never know who's going to be offended in that moment or insulted in that moment. What about social media and online activity? That's the online activity can constitute harassment, even occurs off the clock or offsite. I've talked about that. The flirting and requests for demands to go out on a date, sending inappropriate pictures or videos that are sexually graphic, using sexual language or comments of a degrading nature, cyber stalking, using social media, whether it's Facebook, Twitter, LinkedIn, Instagram, YouTube, Snapchat, to send communications of a sexual nature, not appropriate, and can create unlawful harassment, even though it's off business hours and it's not within the brick and mortar of your organization or of your employment. Intent versus impact. Nobody cares that you didn't mean anything by it. Nobody cares that you were just joking. The law, the HR, the employer, the manager, myself, the judge, the jury, the investigator, we're going to look at the actions. What was the impact, not the intent, the impact of your actions, your behavior, your conduct on someone else. So if you experience or witness or become aware of unlawful sexual conduct or any other offensive conduct of a sexual nature or otherwise, tell the person to stop. They must stop. And always you have the right to report the harassment to someone in the organization, such as human resources or an office manager, without fear of retribution. So let's talk real quick about the reporting of harassment. There's several options. When you report harassment, you can do one or more of the following. You can report the incident to your employer. You can call the state of Illinois. There's a sexual harassment and discrimination helpline. You can file a charge with the Illinois Department of Human Rights. You can file a charge of harassment discrimination with the U.S. Equal Employment Opportunity Commission. You could do all four if you want to. I think it's really important that we have internal reporting policies, and I think it's important that employees report incidents of things that are going on in the workplace that they find to be harassing or discriminating to their employer. Whether it's your supervisor, whether it's HR, whether it's any other designated harassment reporting officer or manager. While the law does not mandate the employee to first report incidents of harassment or harassing or discriminatory behavior to the employer, oftentimes the most effective way to resolve workplace issues is to alert responsible management or internal HR personnel so that prompt remedial action can be taken. You also have the right to call the helpline. Illinois has established a sexual harassment helpline. It's 877-236-7703. Calls are confidential, can be made anonymously, and there's representatives that are there to navigate through your options of reporting and seeking other counseling, assistance, or just frequently asked questions. anyone can file a charge with the Illinois Department of Human Rights. Individuals have 300 days from the incident to file a charge with the agency that's responsible for enforcing the Illinois Human Rights Act. Everything that we've been discussing, the Illinois Department of Human Rights is the state agency, the government agency in Illinois that's responsible for enforcing, investigating the Illinois Human Rights Act. And the Illinois Department of Human Rights has jurisdiction to investigate employers who have just one employee or more. The contact information from the Department of Human Rights, you can call them 800-662-3942. You can go online at illinois.gov/BHR, and then they have offices strategically located throughout Illinois, whether it's Chicago, Springfield, or Marion. Remedies available. So I get this question a lot. Well, what happens if I am a victim of unlawful, not just harassment, not just annoying conduct in the workplace, but conduct that gets to that level of unlawfulness? What happens if there is unlawful harassment? Well, the Illinois Department of Human Rights will complete its investigation, and then the person would then be able to file a lawsuit in court, or they may file a complaint with an agency that's called the Illinois Human Rights Commission, which is to adjudicate, which would hear actual evidence and ultimately make a finding either for the employer or for the employee. Filing a complaint with the Illinois Human Rights Commission is allowed if the Illinois Department of Human Rights actually finds substantial evidence of a violation. But even if the Illinois Department of Human Rights doesn't find substantial evidence of a violation of the Illinois Human Rights Act, at some point, the individual can always pursue relief in court. Ultimately, if somebody wins and prevails before a court or before the Human Rights Commission, they will be entitled to a make-whole remedy. Those remedies may include back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement, front pay where reinstatement is not possible, and attorney's fees and costs. Victims have an affirmative duty to prove damages as well as to mitigate losses and damages. Now, another reporting option is to report instances of harassment or discrimination, including sexual harassment, to the Equal Employment Opportunity Commission, the EEOC. That's the federal agency. So you've got the state agency, the Illinois Department of Human Rights. You got the federal agency, the EEOC. Complainants, again, have the ability to file that charge, similar to the Illinois Department of Human Rights within 300 days. And then the EEOC has jurisdiction to investigate employers, particularly under Title VII of the Civil Rights Act, which includes the sexual harassment component on the federal level for employers who have 15 or more employees. And again, there's online, there's an 800 number for the EEOC. The EEOC.gov is their online presence, and they have offices in Chicago, and they also have an office out of St. Louis. And remedies available under Title VII, it's very similar to how under the Illinois Human Rights Act, but different, because the EEOC, whether they find reasonable cause to believe that harassment or unlawful harassment or discrimination occurred, ultimately the complainant, the employee, has the right to file a lawsuit in court. And so if they were to file a lawsuit in court, the award of remedies would only be made by a court. That's similar to Illinois. The remedies, if somebody is in fact a victim of unlawful harassment and discrimination, ultimately a court or the Illinois Human Rights Commission that's when the award of remedies would be made to an employee. And under federal law, a court would have to award remedies to the employee under Title VII. Those remedies can include back pay, lost benefits, again, clearing of the personnel file, but they also include punitive damages. Now, victims have, under federal law, punitive damages are permitted, but victims have to they have to prove those damages, and they have to mitigate losses and compensatory and punitive damages, if any. Punitive damages are not automatic. The punitive damages and compensatory damages are subject to statutory caps. There are limits under the federal law with compensatory and punitive damages. Employer responsibility for sex harassment under the law. Employers are responsible for sexual harassment in two ways. You've got manager, supervisor harassment, you've got coworker and non-employee harassment. Employers are liable for sexual harassment that's perpetrated by members of management, regardless of whether the employer knew of the harassment. Coworker and non-employee harassment, employers will be liable for sexual harassment perpetrated by an employee, a coworker, or non-employees for that matter, only if the employer knew or reasonably should have known of the harassment and failed to take corrective action. So under Illinois, this is unique to Illinois law. This is unique to sexual harassment. Managers and supervisors, if you're the ones harassing and it's sexual harassment and it's unlawful sexual harassment, there's strict liability if it is at the hands of a supervisor, a manager, a lead. Remember, members of management, you're the eyes and ears of the company. You're the eyes and ears of the organization. Management has to be aware of what's going on in the workplace. The law assumes management is aware of what's going on. It's critical. Leads, supervisors, managers communicate workplace issues and disputes in a way that allows your employer to proactively react in real time and respond in real time and resolve in real time issues and disputes. Remember that risky behavior? Let's identify it and let's be proactive so that risky behavior doesn't turn into and develop into a hostile work environment that would be deemed unlawful under Illinois or federal law. Employer responsibilities. You have a responsibility to prevent, investigate, and correct workplace incidents of harassment or discrimination. You have a duty to prevent, investigate, and correct. So for prevention, it starts with policies, it starts with training, and communicating those policies to your employees. Ensure clear communication on how to report incidents of sexual harassment or conduct of a sexual nature, or all forms of harassment or discrimination. Managers and supervisors should monitor the work environment to ensure the workplace is free of sexual harassment. Supervisors, you need to be aware of your conduct and the conduct within the folks that you supervise, directly or indirectly. Managers and supervisors need to lead by example. Hey, don't engage in conduct of a sexual nature. Don't tell the dirty joke. Managers and supervisors should conduct a climate check. Have the pulse of workers. Confront risky behavior, inappropriate behavior in real time, and prevent it from happening again in the future. It's going to save you time and trouble and headaches, and it's going to help create a more safe and inviting work environment for all. Investigation. So we try to prevent, but we inevitably bad things will happen in the workplace. Things go bump in the night, and so we have to investigate when things happen that we try to prevent from happening. So we want to respond to complaints of harassment, sexual harassment, or other forms of harassment, and initiate investigations quickly, efficiently, or interview the victim. Take reasonable action to protect the victim from retaliation or experiencing further sexual harassment during the investigation. Interview all relevant witnesses. Interview the alleged perpetrator of the sexual harassment or any other form of harassment. Document the investigation results and maintain the file as an employment record. And of course, take corrective action to make sure, corrective measures to make sure it doesn't happen again. That can include disciplinary action, up to and including termination of employment. The employer typically is taking corrective action, not based on the law being violated, but based on the fact that their policy has been violated. I encourage employers to adopt policies that are not going to allow and are going to specifically prohibit action and activity in the workplace that never gets to an unlawful level may be inappropriate, may be unprofessional. We're trying to weed out and trying to prevent unlawful activity in the workplace. So whatever your policy is set up to, is designed, it should be designed to be less tolerable of what the law would otherwise tolerate, if that makes any sense. In situations where the conduct in question did not rise to the level of unlawful sexual harassment, for example, or a violation of your policy, it's nonetheless concerning. So proper counseling, training, and close supervision of those involved is appropriate. We're going to take reasonable action within the organization to reduce the likelihood of future sexual harassment incidents or any other form of harassment. Updating your policies, communicating those to the workplace, to the workforce, providing supplemental or tailored training unique to your organization, perhaps. Restructuring the work environment or reporting relationships appropriately. Following up with the victim. Whoever complained, follow up with them at regular intervals in the future to make sure they're okay and they're not experiencing reoccurring acts of harassment or acts of retaliation, whether it's by the original perpetrator or someone else within the organization. Ensure that the complaining behavior or conduct does not continue going forward. Key to avoid harassing or discriminatory conduct in the workplace, don't be that person. Figure out how your conduct is affecting the people you work with. Make somebody uncomfortable, don't do it. If that is not natural for you, you just don't work that way, you don't know, you feel like you're walking on eggshells, fine. Rule of thumb, good rule of thumb. If you wouldn't say it or do it in front of your loved one, your significant other, the person that you love and respect most on this earth, don't say it or do it in the workplace. Retaliation, the company will not punish. An organization, an employer cannot punish an employee or discriminate against the person for engaging in protected activity. Protected activity includes accusing somebody of sexual harassment or discrimination, supporting someone else's harassment or discrimination complaint, or participating in the investigation. If you complain and provide any statement in good faith, even if you're mistaken, you're protected from all forms of retaliation. Now, you submit willfully false complaints and you provide knowingly false statements, well, then you wouldn't be protected. Retaliation is not just termination. Retaliation can take other forms, the demotion, the suspension, the denial of promotions without any legitimate business reason, unsubstantiated negative evaluations, reprimands for no legitimate business reasons, further acts of harassment or intimidation or threats. And finally, in conclusion, just food for thought. While the law defines harassment and discrimination and the standards that can be very complex, the reality is that the workplace strives to create and implement policy and practices that are more in line with professionalism, fairness, respect, courtesy. We treat people with respect and courtesy, and we're fair-minded. And as we interact with folks on a daily basis, we're going to be all right. So that's the end of the presentation. That's the end of the training. And for those of you that are looking to make sure that, it's your responsibility to make sure that you're certifying that you've completed the training and your employer is documenting that certification, that the training has been completed, please take note of slide 49, and I wish you nothing but the best.
If you think of any questions after this training, feel free to email Jeff or myself and we will get you an answer. Thank you for joining us for this webinar, and thank you, Jeff, for the presentation. This concludes our webinar, everyone. Have a great day.